Good morning. Under the rules, the attorneys for both sides are permitted to make their opening statements, which shall consist of a brief statement of the nature of the case that the party expects to prove and the relief sought. Because of the unusual status of this case, I'm going to read a statement similar to the one I read to you yesterday morning. This is information from the court. Plaintiffs Neil Heslin and Scarlett Lewis, the parents of one of the children murdered at Sandy Hook Elementary School, have sued Alex Jones and Free Speech Systems, LLC for defamation and intentional infliction of emotional distress caused by public statements made by Alex Jones and Free Speech Systems, LLC. You are not here to determine if Mr. Jones and Free Speech Systems, LLC defamed or intentionally inflicted emotional distress on Mr. Heslin or Mr. Lewis. The court has already found that they have committed these acts. The jury's job will be to determine what sum of money, if any, would fairly and reasonably compensate Neil Heslin and Scarlett Lewis for the damages they incurred that were proximately caused by Mr. Jones and Free Speech Systems, LLC's conduct, as well as what sum of money, if any, should be assessed against Mr. Jones and Free Speech Systems, LLC as punishment for their conduct. Ordinarily, at this stage of the case, the jury would hear all of the evidence on damages. In this case, some of the evidence will be presented after you decide compensatory damages and will be followed by a second charge of the court. Okay, just so you understand what's going on.
After July, we have quiet from InfoWars on this topic.
I would object to the reasons you just discussed about the motions to claim that InfoWars was supplied in July, so whenever
I'm free to discuss what I believe the evidence will show.
You are free to discuss what the evidence will show, but liability has been established in this case, and you are close to the edge on that. So please be more careful.
And the judge has already found InfoWars, or Free Speech Systems, parent company for InfoWars, and Alex Jones guilty for those statements. But you are free to consider the intent with which they were made in determining whether they were made maliciously or in good faith. And you're going to hear from the reporter who made the statements.
Your Honor, I'm going to have to object again to the found content.
So you're going to have to explain the difference between defamation and intentional infliction of emotional distress. Intentional infliction of emotional distress, for which Alex Jones and Free Speech Systems, LLC have already been found liable, includes the state of mind of the actor, which means it has already been established that the acts they took to inflict the emotional distress were intentional. Defamation does not include that in the same way. So you're going to have to clarify that if you're going to go down that path.
I think the court has already clarified. And I want you to ask yourself, at the end of this case, is this an honest attempt by personal injury lawyers to get just compensation for damages that were actually experienced? Or is this a cynical attempt by personal injury lawyers to enrich themselves while silencing a political opponent and limiting every American's right to choose what they watch and what they listen to? I look forward to presenting this case to you.
All right, thank you, Mr. Reynal. Before we break, I see people with gum in their mouth. It's clearly stated on the door, there is no eating, there is no gum in this courtroom. If I see it again, I'll stop. I'm talking, sir. The number one rule in court, fair or not, is when the judge is talking, nobody else is, even if I interrupt someone. There is no chewing gum, there is no soda, there is no eating in this courtroom. If I see it again, I'll have you removed. There is no recording of any kind of the YouTube feed or the proceedings in this courtroom without prior written permission signed by me. No photographs, No audio recording, no video recording. So I'm not taking away everyone's phones in the room, but if we find out that you're doing one of those things, you will be removed. There is no talking to, talking in front of, or approaching by anyone of my jury. If somebody does that in the courthouse, they will be removed until this trial is over. Just want to make that very clear to everyone. We're going to break for lunch. It's noon. We're going to break until 1:30. My jury can go ahead and head on out. If the lawyers need me,